Ready? Exercise number 5, legal matter, start. This appeal arises from the judgment and order dated 4th of November 1999 of the High Court of Judicature at Allahabad, whereby the High Court had partly allowed the appeal of the accused/appellants herein, thereby setting aside their conviction and sentence of imprisonment for life under section 302/34 of the Indian Penal Code under bracket for short the IPC, imposed by the 8th Additional Sessions Judge Bareilly UP, and instead convicting and sentencing them to 7 years rigorous imprisonment under section 304 part 2 read with section 34 of the IPC. The accused/appellants under bracket for short the appellants bracket out before us are Mahabir, Nazu, Dharmpal and Sheru, whose fluctuating fortunes shall be set at rest by us in this appeal. Stop. Next para. There was an exchange of abuses between Dharmpal and Rajpal. Thereafter, Rajpal left the place and proceeded towards the southern side. Meanwhile, all the 4 accused came there and assaulted Rajpal with lathis, who sustained head injuries and fell down. The accused thereafter fled from the spot. Raghu, father of Rajpal, arrived there shortly and took him to Faridpur police station on a bullock cart, where Rajpal himself dictated a report of occurrence. The report was registered under section 323 of the IPC against the 4 accused as a non-cognizable report at 21:10 hours on 5th of June 1978. Rajpal was medically examined at the Primary Health Center, Faridpur, at 10 p.m. on the same night. He, however, succumbed to HL injuries. Stop. Next para. After Rajpal died, information was sent to the police station and the case was converted into one under section 304 of the IPC. Thereafter, the case was investigated by Sub-Inspector P.C. Sharma, who submitted the charge sheet against the appellants on 28th of October 1978. The learned magistrate took cognizance of the offence and committed the case to the Court of Sessions. The Sessions Judge framed charge under section 302/34 of the IPC against all the appellants who pleaded not guilty and claimed to be tried. 9 witnesses, including 3 eyewitnesses, were examined from the side of the prosecution. 2 witnesses were examined by the appellants in their defense. Stop. Next para. We have heard the learned counsel for the parties and examined the entire materials on record. We shall now deal with each of the questions raised before us by the learned counsel for the parties. Stop. Next para. The learned counsel for the appellants at the first instance submitted that since the appellants were not served with a notice of appeal in the High Court, the appeal was disposed of by the High Court ex parte without affording any opportunity of hearing to the appellants. Our attention was UP under bracket 1996 4 SCC 720 to drive home the point that the High Court was duty bound to ensure proper compliance with sections 385 and 386 of the Code in disposing of criminal appeals when the accused did not appear, and that the appellate court must dispose of the appeal on merits after perusal and scrutiny of the record, relying on the decision of this court in the case of Bunny Singh (Supra). The learned counsel for the appellants sought to argue that the High Court was not justified in deciding the appeal on merits without giving any opportunity of hearing to the appellants. Stop. Thank you very much.